You're listening to continuing coverage in the suitcase murder, the trial of Sarah Boone, from the Hidden Killers podcast and True Crime Today. Now back to the courtroom.
Then Mr. J goes, I think he gets confused about an issue relating to a diagnosis of an adjustment disorder or anxiety disorder. So we get down to the bottom of page 41, line 22, Mr. J. Okay, so on this topic, if something new comes up, then we can address it. But if we have other topics to depose her on, then I would suggest we go on. And then page 42, line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot and formulate any other opinions, just let the state attorney know and we'll address it. Line 7, the witness, absolutely. That was our understanding. I've been ambushed by a new opinion that I was not made aware of by any kind of report. I was not notified by Dr. Werner. I was not notified by the state attorney, William J. I first heard about the opinion when she testified to it, and I objected to it, relating to imminent threat, the ultimate issue of fact. I move for a total dismissal for prosecutorial misconduct.
Denied. And here's the other reason it's denied. Page 38 of the deposition, specifically that you made reference to, starts at page 21, line 21. The question preceding that is important. Question 14. So, from my understanding, when you just said was, yeah, I agree with general anxiety disorder that she had been diagnosed with. Answer, no. I said it would be generalized anxiety disorder versus adjustment disorder, and that I hadn't had time to fully formulate that opinion out. This entire conversation pertains to those two issues. Anxiety disorder and adjustment disorder. Has nothing to do with PTSD, nothing to do with battered spouse.
But Judge, we go on, and I see what she's doing. That she's saying, hey, I got jammed up, I had a deposition yesterday, I didn't really have time between the evaluation and the deposition 2 days later. She had a deposition in between to really think about it, really review my notes. So as a catch-all, I said on page 40, if you have other opinions or other diagnoses after she has more time to think and review the paperwork, then obviously that creates an issue. So yes, that was initially what she was talking about specifically, but I realized what she was saying was she was going to have to reflect on a lot of these opinions. So
That's respectfully, sir, that's not what it says. That's specifically in line with the anxiety disorder versus adjustment disorder. That was the entire topic that was being conversed with. Now, later in the deposition, there are references, as I believe that I identified previously. Give me a moment. On page 59, line 22, question is asked, okay, and do you intend on expressing any other opinions other than what we've spoken about here today? Line 25, no. I will answer whatever questions I'm, moving to page 60, line 1, asked. Page 60, line 11. Well, let me just start with 2 because it gives it more context. Question, well, I'm asking now. I mean, you're the expert. I'm not. You're the one that's evaluated her. You're the one that's given her the test. I don't know the field like you do. You know the field. I understand you've said, hey, I want to think some more about, hey, I want to think about this some more. I want to review my notes. Some more to see if, but in terms of right now, without any further reflection, without any further answer, yes, sir, question, reading of the notes, any other opinions that you think you could express in any form or fashion with all this experience, almost 1,000 jury trial or 1,000 trials you've testified as an expert. Anything else that comes to mind that may be an opinion that you might express in Sarah Boone's case? Answer. anything else that I'm asked with regard to her diagnosis come into play with regard to her case, I guess. Question: what other opinions do you believe you're qualified to express as it relates to Sarah Boone and the facts and circumstances relating to this case? Anything with regard to her diagnosis, I guess. 61. Of those 4 things we mentioned, line 2, correct.
And Judge, the 4 things were mentioned were related to the anxiety disorder, the narcissism, the battered spouse, the alcohol use disorder, which are in pages 58 and 59. But the overall thrust of that was any other opinions that were expressed. That was in good faith what we were doing. I would have, like I said before, I would have never taken her deposition. Once she said I hadn't finished my analysis and I may need additional information, just like he said the other day, Dr. Harper, if you get those additional medical records, Mr. Owens, about Jorge Torres and give them to Dr. Harper, then I'm going to want to take her deposition again. The same rules apply. Why would I take her deposition when she hasn't finished her
Because the court
analysis?
ordered you to take her deposition because there were concerns about being able to have all of this done prior to trial. And you had concerns about what she was going to testify to. And the court set a scheduling order as to when, how, where, and the deadlines for those depositions to be conducted.
That prosecutor should have let me know. If he was going to ambush me at trial, I should have known beforehand about a new opinion that Dr. Warner was going to express, especially related to battered spouse, post-traumatic stress, and whether or not there was an imminent threat at the time of this event.
And the courts addressed that. Court did exactly what was required by binding precedent by the 6th District Court of Appeal and held a Richardson hearing. Analyzed the 3 factors as required by Florida law with regard to those and gave you the opportunity as a cure. And with regard to your request to strike or dismiss the case due to prosecutorial conduct, the case law by the 3rd District Court of Appeal filed April 10, 2024, State of Florida versus Denninghoff, Denninghoff, and I can provide you a citation momentarily, states that dismissal is an extreme sanction to be used with caution and only when a lesser sanction wouldn't achieve the desired result. Specifically, dismissal of an information or indictment is an action of such magnitude that resort to such sanction should only be had when no viable alternative exists. There were multiple viable alternatives, including but not limited to my request, an inquiry of whether or not you wanted that struck, and the instruction to strike that opinion, which you demurred and said, no, I want it for cross-examination, and I gave you the opportunity twice to depose her here in open court, which I oversaw with regard to any opinion that she based on the proffer or any other opinion that she would be offering today. For those reasons, the court is not going to exercise its discretion and strike due to the extreme nature of striking a criminal charge and for the adequate remedy that has been provided to you. Is there anything else, sir, we need to address?
May I supplement the record?
Yes, sir.
Judge, this deposition did not end on page 40 or 41 or 42. Mr. Owens took a direct examination of this deponent for 68 pages, and then it was turned over to myself for cross-examination during the deposition. Beginning on page 75, I asked the deponent, what did the defendant say about the murder? What she said on page 78 was that, starting at line 13, and she said there was a suitcase and some clothes that had gotten out to donate, and they were trying to get that together. And it was on the floor in the living room. And that, as she was coming down the stairs, she saw him kind of slipping into the suitcase as a hiding place. As she said, I saw him in the suitcase and I zipped him up and we were laughing. She said then he said he couldn't breathe, and I remembered feeling I couldn't breathe when he was choking me or sodomizing. And I was angry and I shook the suitcase. I lost control of the suitcase and it flipped. And she goes on and on about what happened. Defense counsel was there. He heard this testimony that there was no imminent danger presented at the time that she began getting angry, shaking the suitcase, hitting him with a bat, so on and so forth. And he didn't ask her that question after she had specifically instructed him, if you need an opinion of mine, you've got to ask me the question. It's unfair to experts to be thrown with this catch-all provision of please tell me any opinion about this case that you may think is relevant. Well, what the doctor may think is relevant is different than perhaps what counsel thinks is relevant. So it's really an unfair criticism of the state and probably more likely self-reflective that this deposition, this opportunity to ask about this obvious issue did not occur. So that is what I would like to supplement the record with. The deposition was substantially longer than page 41 or 42 where it's acting like it's concluding and, is there anything else? The state would just submit, I understand very well what my ethical duties are. I do not have any ethical duty to provide him an unrecorded statement that is not inconsistent with prior testimony. This doctor did not give me any unrecorded statements inconsistent with her testimony. Thank you.
Thank you.
Judge, I'd like to add on page 79 that Dr. Warner claims that Sarah said he put his 2 fingers out and I hit them with a bat. So there was rule of completeness, but for him to say that that's not standard operating procedure when you're taking a deposition of an expert.
Mr. Owens, I've ruled, sir. I understand. I understand your position. However, the questions that were specifically asked, which gave rise to this, specifically pertain to opinions of PTSD. I'm not going to rehash any and all of those things. The record speaks for itself. The court has ruled. Your motion for dismissal of the charges is denied. For the record, the citation that the court relied upon with regard to Denninghoff is located at 388 Southern 3rd, 10055, located at pinpoint 1057, Florida, 3rd District Court of Appeal, April 10th, 2024. With that, are we ready to bring back in our panel?
Statements.
No, sir.
Okay.
Judge, I've got Earhart's Florida Evidence 2023 edition, volume 1, Charles W. Earhart.
Let me tell you how you're going to rule on this, sir. I'm going to allow you, as I said up here at sidebar, to go into the facts that she relied upon and what it is that she utilized. I'm going to allow you, sir, as I said up here at the bench before the lunch hour, to go into those opinions that she didn't offer here today. And on rebuttal, Mr. J, I'm not going to allow you to stand up and say, may I voir dire, that wasn't one of your opinions today. You can address all of that and redirect. Is that clear?
Clear to the state.
Judge, let me just review to see if, because I had several.
What you had inquired of me, Mr. Owens, up here, was that you wanted to go into these other facts, medical records, text messages, statements, and you said, if I can't do it now because he's going to object, I'm going to call her and assert rebuttal. And the problem, as the state pointed out, is that you can't use her as a conduit to admissible evidence on direct examination. And that if you want to do it, you got to do it now. And your argument was it goes to her bias, it goes to her credibility, and that you're permitted wide discretion on cross-examination. I agree with you. I agreed with you before the lunch hour. My ruling hasn't changed. I'm going to absolutely allow you to go into those things.
I appreciate that, Judge. The other thing I wanted to readdress was
I'm taking care of it, Counselor. Give me a moment. Yes, sir.
Judge, I'm referring to Earhart's treatise, section 90.703, opinion on the ultimate issue. I'm on page 933. Testimony in the form of an opinion or inference otherwise admissible is not objectable because it includes an ultimate issue to be decided by the trier of fact. And in that section, 703.1, it talks about that opinion testimony is not inadmissible solely because it includes an ultimate issue to be decided by the trier of fact. The provision is equally applicable to expert and lay witnesses. The jury has the power to accept or reject the testimony of expert or lay witnesses and is not bound by their conclusions. Merely because a witness expresses an opinion to an ultimate issue does not compel the jury to find that the facts to be true. The jury will be given the opinion. The jury will give the opinion as much weight as it feels the opinion deserves. Then it goes on. The abolition of the rule against opinions on the ultimate issues does not mean that all other opinions are admissible. Witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case. Witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury to determine what occurred. For example, a witness cannot express his or her opinion as to the guilt or innocence of a criminal defendant. And I'm on page 940, 703.1 still. When a witness is asked to express an opinion that applies a legal standard to a set of facts, which Dr. Warner did, the opinion testimony is generally inadmissible. The danger is that the witness will apply a standard or definition which is different from that defined by the applicable law. The application of erroneous legal standard results in the opinion testimony being misleading and not helpful to the jury. For example, an expert cannot opine whether a nursing home was negligent in its care of the decedent.
It's exactly what we spoke about at counsel's table.
I know, Judge, but if you go on, it says an expert may not be permitted that a truck driver drove in a grossly negligent manner, whether the sheriff's conduct was unconstitutional, whether certain waters are navigable, whether the defendant's action constituted misapplication or concealment of funds, or the legal obligations of the parties to a contract, whether the testimony of the expert is a permissible factual conclusion or the impermissible application of a legal standard or definition to a set of facts is sometimes a fine distinction involving a large measure of discretion with a trial judge. For example, the admission of expert testimony that certain investments, it goes on. However, the witness expresses an opinion about the intent of the accused. The opinion, this is one of the important sections. However, if the witness expresses an opinion about the intent of the accused, which Dr. Warner did, the opinion has not been permitted. The distinction drawn by the courts as to when this type of opinion testimony is admissible are often not clear. Section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. This expert testimony regarding substantive legal principles may not be helpful to the jury and may create confusion if an expert testifies in a manner that is different or even in conflict with the testimony of an opposing expert.
But the citations, respectfully, Counselor.
If I could finish.
Respectfully, Counselor, the citations that you're referring to are not at issue. Fluellen, error to permit arresting officer to testify that a quantity of cocaine possessed by appellant indicated that he possessed with intent to sell, which is a specific element of the charge in that case. Gamble, officer's expert testimony with the amount of drugs found in defendant's possession was inconsistent with personal use and therefore intended for sale was inadmissible. 644 Southern 2nd, 1376 for Gamble, and Fluellen, 703 Southern 2nd, 511. The Dinkin case that I read says this is acceptable. If a psychologist or psychiatrist can testify that someone is not mentally defective or was mentally defective, that's on all fours with based on what the defendant had said to this expert. She was not in imminent fear. Now, I don't remember exactly what was said, but it was along those lines, based as looking all those things, the totality of the circumstances of what, in my evaluation, on or about October 2, that the defendant had said to me as the expert, it's not imminent fear. That opinion is not inadmissible per the case law under Dinkins.
Judge, can I read a little bit more It
If you're
applies.
just going to be reading from the treatise, I've already read it.
Okay, well, I just want to make mention, because it's talking about does not prevent a witness to testify about legal conclusions or express opinions on questions of substantive law. And I was about to finish this text, this section, when this testimony, and I'm on page 947, this testimony may also interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. As we know, we're going to do battle over the jury instruction on justifiable use of deadly and non-deadly force. The testimony from Dr. Werner, and I wrote it down, she said based on what Sarah Boone told her, she was not facing imminent risk of harm. That invades the province and function of the trial judge to determine the applicable law and to instruct the jury otherwise, which we haven't even done yet. You haven't made findings of law about which instructions apply. That's what she did, Judge.
Your objection's been made for the record, and the court previously ruled on this matter. I appreciate the additional argument, but the court's reliance on Dinkins remains.
Thank you.
Just because 9703 speaks for itself. So your objection is overruled as to that issue. Anything else we need to address, Mr. Owens, before we bring back in our panel?
No, sir.
State?
Nothing, thank you, Judge.
Okay, let's bring back in our panel.
Judge, should I push the letter now or what?
You can just stay where you are, Counselor. Just wait for them to come in.
Jury's heard.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? Thank you. All could be seated. Members of the jury, welcome back. Juror number 2, back row. He's already ready. I see those hands are raised. You know what's coming. Y'all complied to the court's instructions, right? Thank you. Record reflect all hands have been raised. Mr. Owens, you may continue your cross-examination, sir.
Dr. Warner, I don't want to rehash it, but just for the jury's sake, would it be fair to say that the text messages that you were forwarded by the state attorney for you to review, you did not deem to be relevant to your evaluation?
Right, they demonstrate.
Ma'am, it's a yes or no question.
Yes.
Now, from what I understand, when the state attorney sent you the information, they did not send you any videotapes.
Correct,
So you have not reviewed any videotapes in this matter.
correct.
The suitcase videotapes, either one of those you have not reviewed.
I have not seen them, correct.
Or any body cam videotapes you have not reviewed.
They're described in the police report.
My question is, have you viewed any of the body cam videotapes relating to this incident?
I have not seen them, correct.
Prior incidences between the two of them, have you reviewed any videotapes, body cam videotapes of any prior incidents?
I have not.
Have you reviewed the audio tapes related to some of the questioning of Sarah Boone?
I have not.
Have you reviewed the autopsy report?
It's described in the incident report, but I did not see the actual autopsy report.
Now, you're aware that we have called two experts, Dr. Michael Brannon and Dr. Julie Harper. Is that correct?
Yes.
And you're aware that they are forensic psychologists,
That's correct.
and you are a forensic psychiatrist.
That's correct.
So they didn't go to medical school and you did,
That's correct.
and they don't understand medical issues, so to speak.
I don't have an understanding of what they understand medically.
Do you recall telling me that they don't understand medical issues, so to speak?
They haven't been to medical school, but I wouldn't understand their medical knowledge.
If you would look on page 22 of your deposition.
Objection collateral.
Approach. Objection's overruled.
Dr. Warner, have you had a chance to review your deposition on page 22, starting at line 7?
Yes.
Could you read down through line 11 your answer?
Yes, I'm talking about psychologists in general, not with regard specifically to your experts, which is what you were just asking me about.
Okay, but you would agree, your opinion is psychologists typically do therapy, but they don't prescribe medication or understand medical issues, so to speak.
Correct.
Overruled.
Correct. But I wasn't specifically talking about your experts, which you were just asking me about your experts
Okay.
specifically. And I said I didn't understand, I didn't know what their specific medical.
All right, that's what you said under oath October 4th of this year.
Correct.
Sustained.
Now, is it fair to say that the majority of your work is in the field of competency to proceed and guardianship evaluations?
Actually, the majority of my work is in patient care. I work 7 days a week on the crisis stabilization unit, actually treating patients.
You work 7 days a week.
Yes, sir.
So, as a forensic psychiatrist doing forensic work, the majority of your work in that area is in the field of competency to proceed and guardianship evaluations.
As a forensic psychiatrist, correct. As a psychiatrist, I work 7 days a week on the crisis stabilization unit.
And where is that unit?
It's located in Lake City, Florida.
So you work there 7 days a week.
Yes, sir.
And then you also do this forensic psychiatrist work doing competencies to proceed and guardianship evaluations.
That's part of the what comes under the umbrella of my forensic work, yes.
That's the majority of your forensic work.
Yes, that's the majority of that's the most common cases that we're asked to.
And then next in line would be sanity at the time of the crime.
Yes,
So you would make a determination and submit a report to the court as to whether or not a defendant, an accused, is legally sane or not at the time of the offense.
yes, that's correct.
Is it fair to say that you also testify weekly as a treating physician through Baker Act Court?
Yes, that's correct. Every Thursday, we have Baker Act hearings with regards to our individuals who are being held in our crisis stabilization unit.
Is that in Gainesville or Lake City?
No, sir, that's in Lake City.
Now, Lake City from here is north of Gainesville?
Yes, sir, it's approximately 40 minutes north of Gainesville.
Now, I believe you said you've testified in battering spouse situations in court approximately 5 to 10 times?
Yes.
Is that correct?
Yes.
And you often refer to that as intimate violence cases?
Yes.
Now, my understanding that after you had a chance to evaluate my client, Sarah Boone, and I believe you evaluated her 2 days before the deposition, so it would have been October the 2nd of 2024.
Correct.
As to your diagnosis as it relates to her, do you believe that she suffers from a generalized anxiety disorder?
No, sir.
Now, you're aware that she was previously diagnosed prior to you evaluating her, she was previously diagnosed with a generalized anxiety disorder.
She told me that she had previously been diagnosed. I did not see any medical records with that diagnosis in it, but she told me that she had previously been diagnosed with that.
Did you attempt to secure any other records to us?
Improper.
Sustained.
Did you diagnose her with an adjustment disorder?
I did diagnose her with an adjustment disorder.
Do you believe that if she was diagnosed with a generalized anxiety disorder, it's really not that, it should be an adjustment disorder?
A lot of the symptoms overlap for the two diagnoses, and we see that quite often, that the different diagnosticians or physicians come up with different diagnoses based on a conglomerate of symptoms. So it's not uncommon for the two diagnoses to overlap based on the symptoms.
Do you agree back on October the 4th, 2024, when I took your deposition, that you could not make up your mind at that time whether she suffered from generalized anxiety disorder or an adjustment disorder?
I had not made a clinical decision at that time. I hadn't reviewed all of my documents at that time.
When did you make a clinical decision that she suffered from adjustment disorder as opposed to generalized anxiety disorder?
It was probably within the next week when I was reviewing all of the, going through all of the documents in her interview more thoroughly.
Dr. Warner, did you agree you did not notify me?
Judge, may we approach?
Yes. Objection is sustained.
Dr. Warner, you agree that when I took your deposition on October the 4th, you had questions, in all honesty, about whether or not you felt like Sarah Boone suffered from a generalized anxiety disorder versus an adjustment disorder?
I was leaning towards adjustment disorder secondary to her being in the correctional setting, and I think I said that in my deposition. I didn't know that I had enough information from her because I only had information from her. I didn't have anything in the medical records to support generalized anxiety disorder. So I wanted to review that.
I'm just learning it now as you testified here today.
Sustained.
Is this the first time you've let the parties know that this is your opinion?
That I believe that she has generalized anxiety disorder?
No.
Or that I believe that she has
Adjustment disorder.
Adjustment disorder, yes.
Now, from your evaluation, you determined that she had a personality trait,
That's correct.
and you felt like that she had a grandiosity issue,
Yes, she has a narcissistic personality disorder trait.
a trait, one trait.
Correct.
Do you agree a lot of people have one trait?
Yes.
Okay, a lot of people have a grandiosity trait
Yeah, that's correct.
that are not narcissists.
I never said that she was a narcissist.
Is it your opinion that Sarah Boone has alcohol use disorder?
Yes, that's correct.
And are you forming that opinion based on Sarah Boone's admission to you that she was an alcoholic?
I'm going to refer to my notes for her. She has a history of being diagnosed with that. She also acknowledged to me that her use had been problematic.
So you formed the opinion that she suffered from alcohol use disorder based on the history that she presented to you at this evaluation?
It was based on the totality of the information that I was provided, so the medical records demonstrating that she had been diagnosed with it in the past. Her ex-husband, in his interview in the police report, described her as an alcoholic, and in her description of herself having a problem with alcohol.
Do you acquire a tolerance over time if you drink on the regular?
That's one of the criteria.
Do people also have a genetic tolerance for alcohol?
They may.
Now, as it relates to battered spouse syndrome, would you agree that that is a recognized syndrome in the psychiatric community?
Yes.
And you have heard no criticisms of that syndrome?
No.
And you would agree that's a subset of post-traumatic stress disorder?
Yes.
And you would agree that Lenore Walker first developed the theory of post-traumatic stress syndrome?
Yes.
Now, I think at the time of this deposition, you were not sure you knew Lenore Walker.
I don't recall that.
All right, look at page 54.
Approach. Objection is sustained.
Dr. Warner, do you recognize Lenore E.A. Walker's book, The Battered Woman Syndrome, as an authoritative treatise on battered spouse syndrome?
I do not, because I have not read everything. I haven't read it, and so I can't say that I agree with everything in it.
Is it clear to you that Sarah Boone was involved in a violent relationship with Jorge Torres?
Yes.
Do you agree that there was a violent cycle that occurred during that 3.5-year relationship that Sarah Boone had with Jorge Torres?
It's been described that way, yes.
Would you describe it that way?
It's been described that way to me, yes.
Do you have an opinion?
Vague.
Sustained.
Do you have an opinion that that was a violent cycle between Sarah Boone and Jorge Torres?
It's been described that way, yes.
Do you agree that Jorge Torres was the abuser and Sarah Boone was the victim in that?
It was a volatile relationship. In the police report, her ex-husband actually describes her as being the aggressor.
Okay, I'm going to show you what's been identified as Defense Exhibit I. Have you ever seen this photograph?
I have not.
You see the injuries on Sarah Boone?
I do.
I'll show you Defense Identification H. You see this photograph?
I do.
Have you ever seen it before?
I have not.
You agree that's Sarah Boone?
I do.
Are you aware that George Torres
Sustained.
I'm going to show you defense identification G. Have you ever seen this photograph?
I have not.
Did you ever read anything about George Torres using a curtain rod as a weapon against Sarah Boone?
I don't recall that specifically.
Identification F. Have you ever seen this photograph?
No.
Defense identification E. Have you ever seen this photograph?
No.
Identification D. Have you ever seen this photograph?
No.
Have you ever seen a videotape relating to this photograph?
No.
Identification A. Have you ever seen this photograph?
No.
Now, I believe at the time of the deposition, you had spent I think on October the 2nd of 2024, you had spent 2.5 hours evaluating Sarah Boone, and about half of that time was giving her a test.
No. The mental status examination takes approximately 5 minutes.
Okay. Did you go through her entire history of abuse over the 3.5-year period within the 2 hours and 20 minutes that you had?
No.
Now, I understand that you indicated you may take a couple more hours to go through your file and your notes and to come up with your conclusions. Did you do that?
Yes.
Have you spent any more time on the case other than that 2 hours?
I re-reviewed the documents.
Have you made any other attempts to go see Sarah Boone anymore?
Objection. Proper.
Sustained.
You agree that your opinions are subjective, not based on authority?
They're based on my education, training, and years of experience.
And you would agree they're your subjective opinion?
Correct.
Would you agree that Sarah Boone suffers from battered spouse syndrome?
I do.
Would you agree that battered women's experiences affect their perception of imminent danger?
They can.
Would you agree that victims of repeat violence may fear death in a situation others would not?
They may.
Because someone suffers from battered spouse syndrome, they have a heightened sensitivity to danger.
They may.
You agree that people suffering from depression and anxiety are predisposed to getting into a relationship with a partner who may be violent?
They may. Each individual is different.
Are they more susceptible to getting in a relationship if they suffer from depression and anxiety with a violent, intimate partner?
They may be.
Do you agree that the DSM, I think you have it there with you,
Yes, sir.
directs that the clinician should consider post-traumatic stress disorder if there was exposure to extreme stress. Do you agree with that?
Yes.
Did you do any testing to measure whether or not Sarah Boone had post-traumatic stress disorder?
No.
Is it your opinion that Sarah Boone suffers from post-traumatic stress disorder?
Again, she did not give me enough information to formulate an opinion with regards to that.
You agree that an intimate partner who commits acts of violence, physical violence, against the victim that could cause extreme stress in that individual?
It may.
Do you agree if that is the cause, the violence is the cause of extreme stress, that a diagnosis of post-traumatic stress disorder should be considered?
If they meet the criteria. They have to meet the diagnostic criteria.
Do you agree that there is a sense of learned helplessness when someone suffers from battered spouse syndrome?
Yes, that's part of the syndrome.
Do you agree that these women, these battered women, have learned the probability of receiving a beating, and they recognize specific predictive cues emitting from the batterers?
Yes, but it's not just women.
I understand, but you would agree the vast majority of intimate partner violence, battered spouse syndrome victims are women.
Yes, intimate partner violence, yes.
Excuse me?
Intimate partner violence, yes.
The vast majority, the lion's share, are women.
Yes,
And these battered women have learned the probability of receiving a beating by recognizing specific predictive cues emitted by the batterers.
correct.
And many times, these predictive cues result in a high level of anxiety.
Yes,
And in that situation, the battered women may attempt to reduce through several different means, one of which is to avoid delaying the beating.
yes, we talked about that with the cycle.
What is a basal instinct?
A basal instinct? I have no idea.
Primal fear?
Primal fear is just being afraid.
Is that a natural instinct that animals have?
Yes,
Fight or flight instinct?
yes,
You don't even think about it.
correct.
Do you agree that victims of battered spouse or battered woman syndrome suffer from self-isolation, suicidal thoughts, and oftentimes substance abuse?
They may. Each individual is different, so they may.
And they may show signs of physical injury and illness, such as bruising and chronic fatigue.
Yes, those can be signs.
The syndrome, battered woman syndrome, is the psychological effects of living with an intimate partner violence.
Yes,
They may have intrusive memories,
they may.
or they re-experience past traumatic events in their mind.
Yes,
They have high levels of anxiety,
yes. They may.
hypervigilant when something doesn't seem right.
They may.
It leads to this fight or flight response that we spoke about.
Yes, they may.
They have problems with sleep.
They may.
They often go into denial,
They may.
minimizing what is happening to them,
They may.
numbing their emotions.
Some of them.
Dissociation. A battered woman may often develop a defense mechanism of being able to psychologically detach from their body during the traumatic experience.
Facts on that.
Sustained.
Panic attacks, severe depression, very low self-esteem, poor body image, disassociation, learned helplessness. All these are symptoms of a battered woman syndrome.
Objective, compound, some facts and evidence.
Sustained.
You agree panic attacks is one of the symptoms of battered woman syndrome.
Objective, fact and evidence.
Sustained.
What are the symptoms of a battered spouse syndrome?
They can be numerous symptoms, from anxiety symptoms, mood symptoms. They can have psychotic symptoms. It can be any vast majority of symptoms. Substance abuse symptoms, any vast majority.
Do you agree fear is a symptom?
Yes.
Somebody in a constant state of fear.
Maybe, yes.
In terms of the abusive partner, do you agree that they would hit the victim,
Some of them, yes.
kick the victim,
They may,
punch the victim,
they may.
Choke.
Abuse takes all different forms.
choke,
They may,
burn,
they may,
destroy their belongings,
they may,
use weapons to hurt them,
they may,
threaten to hurt them, their children, or their pets,
they may,
take their car keys,
they may,
take their debit card,
they may,
take their vehicle,
they may,
control where they go and who they see,
yes, they may,
force them to have sex when they don't want to.
yes, they may.
Dr. Warner. I know you spent a short amount of time with her, and you're saying you didn't get some of the answers as to whether or not.
Facts. Stating facts.
Objection sustained.
If you'd have spent more time with Sarah Boone, could you have uncovered as to whether or not she suffered from battered spouse syndrome?
I agree that she met the criteria, or that she had battered spouse.
How about post-traumatic stress disorder?
It's possible.
Thank you.
Any redirect examination?
Yes.
You may proceed.
In your decades of experience, have you ever treated patients that suffer from trauma disorders?
Yes.
How frequently would you say you do that?
I have patients on my unit right now that I'm treating on a regular daily basis who have suffered from trauma.
How about patients that meet the criteria for battered spouse syndrome?
Yes.
How many would you say over the course of your career?
Probably 5 to 6 a month on my inpatient unit.
And that's a lot of months.
Yes.
How long have you been doing this?
Since 1998, when I began my career at the University of Florida on faculty.
Now, on cross-examination, you were asked about some diagnoses, correct?
Yes.
Right. Any of these things that you talked about, narcissistic personality disorder, adjustment disorder, anxiety, battered spouse syndrome, any stress or trauma-related disorder, if the state wanted to ask you those opinions, would you have been receptive to more materials before making any opinions about those topics?
Yes.
And is it your testimony today that you don't have enough information to necessarily make a complete and proper diagnosis on any of those things since you have not been provided those materials?
Correct.
Now, you've testified that she does meet the criteria for battered spouse syndrome.
Yes.
But you would be receptive to any evidence that you were provided, right?
Correct.
Going back to what you testified to on direct when the state asked you your opinion about this case, everything that you just talked about with Mr. Owens, does that change your opinion about whether or not battered spouse syndrome is applicable to the facts as Ms. Boone relayed them to you about this incident?
No, not at all.
And why is that?
Because again, she just.
Objection, Judge.
Objection's overruled.
Based on your conversation with Mr. Owens, you've indicated that your opinion did not change, and now would you answer why?
Yes. So based on my interview with her, the way that she described the incident to me, and that they were laughing and having a good time, it didn't play into relaying any kind of triggers or any kind of trauma.
And I'm showing you what has been marked for identification purposes by the defendant as I. Does this photograph inform you as to what happened?
No.
Does it inform you as to who was the aggressor?
No.
H for identification, same questions. Does it inform you as to what happened?
No.
Does it inform you as to who the aggressor was?
No.
Same questions for G.
No.
F,
No.
E,
No.
D,
No.
and A.
No.
If those specifics as to what happened and who was the aggressor is dependent upon the credibility of somebody, would you want to take into account all the things that can make a person credible or less than credible?
Yes, you would want to take that into account.
And you talked about alcohol use disorder. Would you take that into account if somebody is under the influence of alcohol or had been consuming alcohol when they relay a history as to things that
I'm
happened?
object.
Objection's overruled.
Would you consider somebody's alcohol use and level of intoxication in evaluating the credibility of them as a historian?
Yes.
And you were asked about whether or not you did any testing for post-traumatic stress disorder.
Correct.
And you didn't.
Correct.
You already indicated, however, you believe that Ms. Boone meets the criteria for battered spouse syndrome.
That's correct.
Again, that doesn't change your opinion that you gave when talking with me on direct examination.
Object. Asked and answered.
Overruled.
Specifically about this question about the testing that you did not perform. Did this lack of testing have any change or effect on your opinion as to whether or not battered spouse syndrome applied to the facts of this case?
No.
You were questioned about insanity on cross-examination. You recall that?
Yes.
Would you agree that simply because somebody is mentally ill and meets the criteria for diagnosis such as schizophrenia, bipolar, any of those psychotic or mood disorders, that doesn't necessarily make a person legally insane?
Correct. The two aren't equal.
Likewise, even if somebody meets the criteria for battered spouse syndrome, does that mean every action they take against their intimate partner is justified?
Correct. They wouldn't be equal.
So even if you do have battered spouse syndrome, even if you are in an intimately violent relationship, that doesn't necessarily mean any action you take against your partner is justified.
That's correct.
No other questions?
State, can this witness be released?
Yes, sir.
Defense.
Just if we got a phone number, we can reach out to her.
Okay. All right, ma'am, you're released, potentially subject to recall. Thank you. State, you can call your next witness.
Judge, at this time, the state would move P for identification and evidence.
Is this a videotape or an audio tape?
State moves P for identification and evidence.
What's 18? Got it. Thank you. Okay. Any objection to what was pre-marked as P? Counsel? Any objection to what was pre-marked as P?
Permission of the public?
No, he's offering it in evidence. Any objection?
No objection.
All right, what was pre-marked as P will be received into evidence without objection as states 21.
State will move V for identification, B as in Victor.
Any objections?
No objection.
What was pre-marked as V will be received into evidence without objection as states 22.
May we approach?
Yes. Members of the jury, it is 2:52 in the afternoon. The next part of the state's presentation are going to be some videos and other things that will be read to you that may take a little bit of time based on the length of them. So we're going to go ahead and take our afternoon break at this point in time. Similar instruction I've given to you over the last couple of days. Please do not conduct any independent investigation or research if the person, places, things, or charge involved, and do not have any discussions with anyone or amongst yourselves about those things, and we'll bring in 5 after. Thank you.
Down through.
Y'all may be seated. Thank you. State, anything we need to talk about?
No, sir.
Defense? All right, we'll be in recess till 5 after. Thank you. All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State?
William J. for the state. Dave Castro for the state.
Defense?
James Owens from Miss Boone.
Kevin back on behalf of Ms. Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. It's 3:05. We're ready to bring back in our jury, Mr. J.
Yes, Your Honor.
Defense? All right, let's go ahead and stand and bring back in our panel.
Carries all right.
State, you recognize our jury.
Yes, Your Honor.
Defense, you recognize our jury.
Yes.
Thank you. Y'all can be seated.
Members of the jury, again, do you comply with the court's instructions during our break? All right, record reflect all hands have been raised. Thank you very much. State, you may proceed with the balance of your evidence presentation.
Permission to publish what has been entered into evidence as 22, previously V as in Victor for identification.
You may proceed.
This exhibit 22 has 5 folders on it. It is a DVD. Going into the first folder, OCSO 18-067501.
Counselor, are these audio or video files?
This first one, Your Honor, is going to be a video file.
Okay, let's go dim the lights, please. Thank you.
And for record purposes, its file name ends with 0154-2.
You may proceed, sir.
More continuing coverage in the suitcase murder. The trial of Sarah Boone is on the way. From the Hidden Killers podcast and True Crime Today. Press subscribe now.